Before we proceed, it's important to understand the difference between public discrimination and private discrimination. Public discrimination is discrimination by the government or someone who works for the government. Public discrimination includes laws passed by the legislature or actions taken by any governmental employee, such as police officers or public school teachers. Plessy v. Ferguson involved public discrimination because it concerned a law passed by the state of Louisiana. Private discrimination is discrimination by a private business or by a private individual who does not work for the government. In the civil rights cases, the federal government was attempting to ban discrimination in private businesses such as theaters and inns, and therefore that case involved private discrimination. Knowing the difference between these two concepts is important because, as we have seen, the court approaches the two types of cases differently. This video focuses solely on public racial discrimination after Plessy v. Ferguson. In Plessy, the court established the doctrine of separate but equal, which led to decades of governmentally required segregation and racial discrimination. Since Plessy was a constitutional decision, it could only be overturned through a constitutional amendment or by the court itself. A constitutional amendment was politically impossible, because it would require the approval of 38 states. So the only solution was to persuade the court to change its mind. Thurgood Marshall had a plan to do just that. Marshall was a brilliant man who applied to law school at the University of Maryland, but his application was denied because he was African American. So he then decided to attend Howard University, one of the few law schools in the nation that admitted African Americans. He graduated first in his class, and the first thing he did after starting to practice law was to sue the University of Maryland for denying him admission. He won the case. It was the start of an amazing legal career. Marshall went to work for the NAACP, the National Association for the Advancement of Colored People. Part of Marshall's job involved traveling across the country defending poor black defendants who had been falsely accused of rape, murder, and other crimes. He won numerous acquittals, saving several innocent black men from being executed. But the ultimate goal of Marshall and the NAACP was to convince the Supreme Court to overturn Plessy v. Ferguson. They were especially concerned about the effects of segregation in public education in K-12 schools. So they devised a strategy. They brought a series of cases to the Supreme Court designed to challenge the logical basis of Plessy. One of the very first of these cases was called Missouri v. Canada in 1938. This case involved an African-American Mississippi resident named Lloyd Gaines. Gaines was fully qualified to attend law school, but the state of Missouri only had one law school, and it did not admit black applicants. So they offered to pay for his education if he attended law school in a different state. Mississippi said that this was separate but equal, and therefore did not violate the Equal Protection Clause. The Supreme Court was persuaded by the NAACP that it did. Although the court didn't overturn Plessy, it said that states cannot avoid offering services to non-whites by sending them out of state. In a unanimous decision, the court wrote, "The white resident is afforded legal education within the state, the Negro resident having the same qualifications is refused it there, and must go outside the state to obtain it. That is a denial of the equality of legal right to the enjoyment of the privilege which the state has set up, and the provision for the payment of tuition fees in another state does not remove the discrimination." This was a major victory, and one of the first victories for civil rights advocates since Plessy. But it was just the beginning. Because of this case, states now had an obligation to provide graduate education for black students. But because most southern states did not want to integrate, several of them began creating separate law schools and grad schools specifically for black students. For example, Texas created a new law school for black students in the city of Austin, near the University of Texas campus there. Heman Sweat was an African-American man who was qualified to attend the University of Texas Law School, but he was denied admission solely on account of his race. Texas did admit Sweat to the new law school for black students in Austin, but he refused to go. He filed a lawsuit claiming this violated the Equal Protection Clause. In a unanimous decision, the court agreed with him. They did not overturn Plessy. Rather, they argued that while the two law schools were separate, they were far from equal. As the court's opinion noted, the law school for Negroes would have had no independent faculty or library. The teaching was to be carried on by 4 members of the University of Texas Law School faculty, who were to maintain their offices at the University of Texas while teaching at both institutions. Few of the 10,000 volumes ordered for the library had arrived, nor was there any full-time librarian. The school lacked accreditation. We cannot find substantial equality in the educational opportunities offered white and Negro law students by the state. In terms of number of the faculty, variety of courses and opportunity for specialization, size of the student body, scope of the library, availability of law review and similar activities, the University of Texas Law School is superior. And while the court didn't overturn the separate but equal doctrine, it did make an important change in the way that it defined equal. The court did not merely focus on tangible equality, things that you can touch and measure, such as the number of faculty or books. The court could have just stopped after it had finished discussing these tangible differences between the two law schools. But it didn't. Instead, it proceeded to widen the definition of equality to include intangible factors. It said, "What is more important, the University of Texas Law School possesses to a far greater degree those qualities which are incapable of objective measurement but which make for greatness in a law school. Such qualities, to name but a few, include reputation of the faculty, experience of the administration, position and influence of the alumni, standing in the community, traditions, and prestige." It is difficult to believe that one who had a free choice between these law schools would consider the question close. In addition, the court argued that the mere fact of separation has a negative impact on the quality of education that the black students receive, because black students will never have the opportunity to interact with whites. The court noted that white people constitute 85% of the population of the state and include most of the lawyers, witnesses, jurors, judges, and other officials with whom petitioner will inevitably be dealing when he becomes a member of the Texas bar. With such a substantial and significant segment of society excluded, we cannot conclude that the education offered petitioner is substantially equal to that which he would receive if admitted to the University of Texas Law School. The Gaines case and the Sweat case meant that states had to provide graduate education for non-white students, and that they had to do so in the same institution. But that doesn't mean that the states were done trying to discriminate. George McLaurin was an African-American man who was admitted to the University of Oklahoma graduate education program only to avoid a lawsuit. But the university certainly did not welcome him with open arms. According to the court, McLaurin was required to sit apart at a designated desk in an anteroom adjoining the classroom. To sit at a designated desk on the mezzanine floor of the library, but not to use the desks in the regular reading room. And to sit at a designated table, and to eat at a different time from the other students in the school cafeteria. Oklahoma argued that McLaurin enjoyed tangible equality because he had access to all the same facilities as the white students. But this was not enough for the court. In another unanimous decision, the court found that even if tangible equality existed, intangible inequality also violates the Constitution. The court argued that McLaurin is attempting to obtain an advanced degree in education, to become, by definition, a leader and trainer of others. Those who will come under his guidance and influence must be directly affected by the education he receives. Their own education and development will necessarily suffer to the extent that his training is unequal to that of his classmates. State-imposed restrictions which produce such inequalities cannot be sustained. While the court had not yet overturned Plessy v. Ferguson, Thurgood Marshall and the NAACP had laid the foundation for doing so. It would finally happen in 1954, in the case of Brown v. Board of Education.